This is The Briefing, a podcast presented by Mussio Goodman Law Firm.
So the law is pretty clear that if the estate is large enough, there will be a distribution to all children unless there are some clear grounds upon which to disinherit a child. So what the court does is look at whether there's a legal and moral obligation to the adult children or the infant children. So legal obligations would apply to a disabled child or a child under the age of 19. There's definitely an obligation in law to provide fully for those type of children. In terms of the adult children that aren't disabled or otherwise living at the house because of some sort of condition, then there is still what's called a moral obligation. And the starting ground is basically the law in British Columbia looks at the overall number of children and says, well, everyone should be treated equally, even if the testator decided, nope, I'm going to only give it to a few or one of the children. So you have to show reasons behind why you're disinheriting a child. So in the vast majority of situations, unless there's something that was very, very bad in terms of what the child did or estrangement on the part of the child, in almost all situations, as long as the estate is large enough, there'll be a variation of the will to allow for something to every child, because the law is clear that it's not part of our society to pick one over another, and so the test is the objective nature of the society, meaning that we don't look at what the individual was thinking, we look at what the average person in society thinks is fair. And in the vast majority of cases, a distribution to all children is warranted.